Welcome back my YouTube channel NDS Shorthand. 5 seconds to go. There is therefore no substance in the contention made on behalf of the petitioners that the impugn order under section 18A was vitiated, as no direction under section 16 was issued by the central government. It is urged on behalf of the petitioners that the company was not supplied with a copy of the report of investigation before the impugned order under section 18A was passed. The respondents acted illegally in violation of the principles of natural justice, and the impugned order is liable to be struck down on that ground. In our opinion, there is no substance in this contention. The company was given a hearing by the investigation committee, and therefore it got ample opportunities to make representations against the proposed takeover. It is difficult to lay down and non-supply of a copy of the report of investigation under section 15 of the IDR Act will always occasion a failure of natural justice. Whether in a particular case there has been failure of natural justice or not will depend on the facts and circumstances of that case. As has been laid down by this court of Keshav Mills Corporation Limited versus Union of India within bracket 1973, 3 SCR 22 within bracket AIR 1973 SC 389, that in certain cases where unless the report is given, the party concerned cannot make any effective representation about the action that government takes or proposes to take on the basis of that report, and the non-supply of the report may invoke the application of the rules of natural justice. In that case, it was contended by the appellants that they should have been given further hearing by the government before they took the final decision to take over their undertaking under section 18A of the IDR Act, and that in any event they should have been supplied with a copy of the report of the investigation committee. On the grounds that weight with this court for rejecting the contention was that since the appellants had received a fair treatment and also all reasonable opportunities to make out their own case before the government, they should not be allowed to make any grievance of the fact that they were not given a formal notice calling upon them to show cause why their undertaking should not be taken over, or that they had not been furnished with a copy of the report. In the Eastern case also, as has been already noticed, the company was given a reasonable opportunity of being heard by the investigation committee during the investigation under section 15 of the IDR Act. In our opinion, the petitioners were not in the least prejudiced for the non-supply to them of a copy of the report. It does not appear that the petitioner ever asked for a copy of the report. They did not also move against the order under section 18A before the undertaking was nationalized under the Nationalized Act. It is the case of the petitioners that they did not challenge the impugned order under section 18A because the takeover of the management of the undertaking was for a limited period of 5 years.